Let me thank the other keynote speakers as well. Thank you for kicking us off. I think it's a great start to what we're going to be talking about for the next day and a half. At a conference about small states, integration and logistics are key issues, and one of them, I think maybe this says something about lawyers who we don't count very well. So we have 7 people and 6 chairs and 6 microphones. So we're going to shift now from the keynote speakers to our commentators, and we are lucky to have 4 very experienced commentators who I'm going to ask to make some initial remarks in reaction to the keynote speakers, but then I think the goal is to have a dialogue. So let me introduce our 4 commentators in the order I have them written down. And we can find them on the stage. But first is Professor Francesco Schurr, who is on the right end. He is a professor of law and head of the chair for Company, Foundation, and Trust Law at the Institute for Financial Services, as well as the program director of the Masters of Law in Company, Foundation, and Trust Law at the University of Liechtenstein. Thank you very much for being with us.
Thank you.
We also have Elizabeth Bakibinga-Gaswaga, who is currently the legal advisor for the Rule of Law Division at the Commonwealth Secretariat headquarters in London. And she has had a variety of different positions, including having served as vice president of the Commonwealth Association of Legislative Council and among other things, being principal legislative counsel at the Parliament of Uganda. Thank you for being here. Timothy LeMay, who is next to me, is the principal legal officer and head of the legislative branch of the International Trade Law Division and Office of Legal Affairs, the Secretariat of UNCITRAL, and maybe I should spell out UNCITRAL as the United Nations Commission on International Trade Law. Before his time at UNCITRAL, he was the chief of the Governance, Human Security, and Rule of Law section of the United Nations Office on Drugs and Crime, and thank you again for being with us. And at the far end, on the right, is Professor Baldur Þórhallsson, who's the head and professor of the Faculty of Political Science at the University of Iceland. He's also Jean Monnet Chair in European Studies and Program and Research Director at the Center for Small States at the University of Iceland. And thank you as well. And what I would like to do, and it's cozy, I know, but if I could ask each of you to make some initial remarks, both in response to the keynote presentations, but also generally on the topic of the conference. And maybe if you're comfortable starting just on the left.
I guess this is thank you very much, and I would like to thank the organizers very kindly for the invitation to come and take part in this conference. My name is Tim LeMay. I'm with UNCITRAL, and maybe I should just say a quick word about what UNCITRAL is, the United Nations Commission on International Trade Law. We are an intergovernmental body based in Vienna, and we are essentially dealing with issues of private international law, that is facilitating commerce between private parties. So we're not in the area of state-to-state agreements or customs or trade treaties or that kind of thing. So essentially we deal with issues like arbitration and conciliation, electronic commerce, secured transactions, insolvency, sale of goods, maritime transport, those kinds of issues. I think what we've had today are 3 very interesting presentations from our speakers, which raise a number of issues that come up for us at UNCITRAL. Certainly, integration of functions among small states can act to eliminate legal obstacles to cross-border commerce, and that's what our main function is at UNCITRAL, is trying to eliminate those barriers. It reduces transaction costs. It builds confidence, I think, by making a jurisdiction a more attractive place because it has a more predictable legal environment. One thing that is beneficial, we think, in the UNCITRAL process is it's a very open one. Even though we have 60 member states from all regions, any United Nations member state is welcome to take part in the debates, and indeed any interregional body, intergovernmental body, or even non-governmental bodies which have something to offer to the debate can take part. We realize that even though small states are welcome to take part, as a couple of speakers mentioned, this is often a very difficult thing in terms of resources. Simply having the human resources, the knowledge base, and the the ability to attend the meetings can often be a difficult thing, but sometimes it can help to be represented through a regional body which combines those resources and allows the smaller states to have a voice. So, and all our decisions are not taken by vote; they are taken by consensus. So all voices are heard in the process. Just as an example of a small state taking an important lead, we have recently concluded a convention on transparency in investor-state arbitration. The leading state on that, to my mind, was Mauritius. The chairman of UNCITRAL was a lawyer from Mauritius, and the convention was opened for signature there, and in fact is known as the Mauritius Convention. So there really is a role for a voice to be heard of small states. A number of points came up, so I don't want to, I know this is introductory remarks, but I'll just touch on a couple. Dr. Kessie, for example, mentioned the risk of sometimes, and I think Dr. Barry as well, the risk that subgroups can sometimes be inward-looking and, in fact, result in having a conflict between another subgroup in a neighboring region. This is a problem when you have too many agreements going on at once, which may result in conflicting obligations. I recently attended a meeting of a research group attached to the OAS, the Organization of American States, and their problem was that they had a number of instruments which had been negotiated but were not being implemented. Yet instruments on the same subject matter, which were UNCITRAL instruments, in other words, global ones, had been heavily subscribed. So the question was whether it was not, in fact, more useful to take a global standard and make that something which links the region within itself and with other regions, rather than pursuing a parallel course which might make you rather separate. A couple of other quick points, obviously, and we'll come to this when we discuss arbitration, the use of the courts to handle extremely complex disputes and large disputes like investment disputes. That's a real problem even in developed countries, but for small developing countries to have that kind of capacity it's really very, very hard to imagine. So this is why arbitration seems to be the route that is being pursued for these types of cases, and we know from reading the papers that that arbitration route has controversy attached to it as well, which is why we pursue a path of transparency. But we'll come to the transparency, I think, when we discuss arbitration. Mele Tupou mentioned sustainable development, and this is always the underlying theme now, because the sustainable development goals are the new standard that's been set by the United Nations, and a number of those goals are taken up by UNCITRAL, particularly those that promote and that touch on commercial development and justice development. So UN agencies are really working together to promote the achievement of those kind of goals. I guess the only thing I'd mention for now in these introductory remarks is I was glad to hear Dr. Barry say that the states in his region are looking to take on board the UNCITRAL model law on arbitration and also the New York Convention, because these are both widely subscribed instruments which really set a universal standard for arbitration, not only in the commercial sphere but in the investor state sphere as well, and I think that's a positive development. So if this sounds like an advertisement for UNCITRAL, it probably is, but I think there is a lot that we have to offer as a global body which can be of use to small states which are members of the UN. Let me just finish there.
Yeah,
thank you.
Thanks, Tim. I think we're going to talk a lot about UNCITRAL over the next day and a half, and one of the issues I think for tomorrow as well as today we'll come on to are some of the issues that Edwini raised about the gap of experience and knowledge, and maybe first steps being good law, but then the question of capacity to use that law and experience. And I think one of the challenges that we'll certainly spend some time talking about, but obviously the first step is having good law. Elizabeth, thank you.
Yeah, thank thank you for having me here. By way of introductory remarks, I'll bear in mind 3 points raised by the previous speakers. Yeah, first and foremost, the Commonwealth Secretariat recognizes the sovereignty of member states, including the small states, who are the majority. 31 of the 53 member states of the Commonwealth are small states. And the technical assistance and support provided to the small states is based on requests from the member states themselves. That's demand-driven and not imposed from above. Regional integration is definitely recognized as an important avenue or vehicle through which Commonwealth member states, be it large or small, can achieve benefits. And of the 31 small states, 13 are involved in the 31 member states are involved in 13 regional integration arrangements, the details of which I'll not go into now. A point to note is from Ms. Tupou for Tonga, saying that there is lack of an arbitration law. One of the areas in which the Secretariat is involved in is assisting with the establishment of legal frameworks, support for law reform and legislative development, legislative drafting and provision of model laws. So definitely that will be one of the areas in which we could further discuss with Tonga and other small states to establish a way forward. And when it comes to general areas of technical assistance, the Secretariat has provided advisors, it has provided support at national and regional level. At CARICOM, Dr. Kessie informed me that there are 2 trade advisors presently working in Vanuatu, provided by the Commonwealth Secretariat, and that they're doing a good job. So we are on the ground. The Secretariat acts as a champion for small states, ensuring that there is support with the UN process, providing services in Geneva and in New York, like office services and conference services. As a rule of law division, we are specifically involved in capacity building for judicial officers, for legal advisors, supporting governments. And we also engage in promoting policies which are responsive to concerns of small states. You may be aware that the Commonwealth Secretariat was involved in the development of a vulnerability and resilience framework that is specific for enabling small states to concerns to be taken into consideration in decision-making processes. So by way of initial remarks, that's where I'll stop for now.
Thank you. Thank you very much. Francesco?
So first of all, thank you very much to the organizers, especially to Professor Petra Butler, who was so kind to invite me to this conference. It has been many years that I've shared with Petra, discussing many interesting topics like constitutional law, human rights, and especially private international law contracts, towards many issues that actually are of relevance for small states as well as large states. So I'm really impressed, Petra, of what you have put together here in London with this center that you're co-directing, and all the relationship to these high-profile people, especially also to the law firm that is hosting this event. So thanks to the speakers, I'm really impressed by the statements contained in these presentations, and there is actually 2 issues that I would like to raise. The first one regards problems with the enforcement and dispute resolution that were raised, especially by Dr. Kessie and Mele Tupou, about basically problems with the, how can we trust local judges, probably from a foreign perspective. At least there's some interpretation that I'm giving. How can complex scenarios of investment be enforced? And my point of view, and of course I would also like to formulate it as a question, but first of all as a statement, what can we actually do and what should be done to change that? Because I'm of the opinion that small states, no matter how small they are sovereign states, and sovereignty is expressed through institutions that allow the enforcement of the law locally. So the international players, from my point of view, should have a choice whether they refer to the local enforcement agencies, courts, or whatever it is, or whether they refer to international arbitration. So they should at least have a choice, because otherwise the whole sovereignty is undermined. And so if we're talking about projects and support, I think this should be the first point where actually support should be given. And I might also argue, out of my experience, as you have read from my CV, I'm based in the Principality of Liechtenstein, and the Principality of Liechtenstein, when it gained sovereignty in the 1920s, it was a state that had no resources at all. It was one of the poorest countries in the world, and now it's basically at the top of the list of the richest countries in the world. And this happened through the export of the law, just the law, and the proper mechanism of law enforcement. And I might have an opportunity later on also to talk about that. So this will be my first question also to the speakers and comment. And a second issue that I would like to address, and Dr. Barry mentioned that at the beginning, is the definition of small states. Well, I'm definitely, I'm more a trust law and company law person. I'm not so much involved in, political and constitutional issues. But to me, it seems a bit, I'm not 100% happy if we just draw the line with the population. I guess we should look at how much influence the states have, on the rest of the world, because as it has been shown impressively on the last example regarding Mauritius, that basically small states sometimes can really change something, and maybe even though they don't gain a hell of population, they might not be small states any longer, but they might really have a saying in the world. Like Luxembourg, for instance, within the European Union, has an incredible amount of power, and you wonder, where this power actually comes from. If you think about Luxembourg, I guess, is allowed 600,000 or 700,000 people. So, again, this could be a question to Dr. Barry. Thank you.
Thank you, Francesco. Baldur, some initial comments?
Yes, thank you very much. So first, thank you very much for the invitation, and thanks for excellent keynote speeches. I come from a small state, Iceland, with only 330,000 inhabitants. We are close to the Arctic, unfortunately, not located in the Caribbean. Yes, and how to define small states. I've been working on small states for a long time, mainly small states in Europe. And in my field, political science, we define all the Nordic states as small states when we compare them to the bigger European states like the United Kingdom or Germany and France. And then on Iceland definitely a small state with only 330,000 inhabitants, but when it comes to fisheries and our rich fishing ground, our annual overall catch is 1/3 of the total EU catch of fish. So that's make Iceland, according to ourselves, superpower when it comes to fisheries. What I think these speeches have in common is that they laid out very well inbuilt structural weaknesses of small states. Small states are vulnerable. They are vulnerable mainly because of three factors: because of their small domestic market, because of their small public administration, and they are small because they cannot defend themselves from a hostile attack. So from my point of view, what is most important for small states to do in the beginning is to acknowledge those weaknesses. Acknowledge these weaknesses. Because if you don't acknowledge them, you will not compensate for them. Small states can't overcome these weaknesses, but they can't compensate for them. And that's the key thing. And what can they do? There are two elements here. They have to make domestic arrangements and then external arrangements. What do I mean by domestic arrangements? Domestic arrangements can include simply to develop good governance. Another example, simply to develop efficient and competent economy. When it comes to external arrangements, I think it's extremely important, as all of the speakers have already laid out, which is to seek or to form an alliance with a large state or a group of states. In my terms, or what I've been working on, I've been writing about the importance of small states to seek alliance shelter by a larger state or multilateral organizations. So what small states need, they need political shelter, economic shelter, and societal shelter. What do I mean by this? Just shortly, economic shelter can simply include access to a common market, taking part in a currency union, or getting direct aid to implement trade agreements, as has already been mentioned. Political shelter can include direct diplomatic assistance. Some of our small states have so small foreign services, they simply are in need of diplomatic assistance from regional or international organizations. And then third, small states, from my perspective, need societal shelter in order to avoid isolation, in order to avoid stagnation. And at least the political science literature neglects the importance of social communication, import of norms and values. I'll leave it here. But if I may just ask the speakers a question, or for us to think about, what is the best way for small states to overcome their weaknesses? What's the key?
We've got a question. Do we want to try to tackle that question? What is the best way? Edwini or Mele? David? Anyone want to? It's a broad question, and if you could give us a good answer,
I'll give you a broad answer. I'll give you a broad answer to a broad question. I think there has to be a number of overlapping ways to address weaknesses. It depends upon what the weaknesses are. You've talked about forming alliances with states, and this really addresses the comment made by Timothy LeMay, which is why have two integration movements which do substantially the same thing within the same geographic space? Well, one of the things you can do in CARICOM, the OECS, made up of 7 member states, share a much closer history, geography, GDP. Every feature is very similar. They're all small island states. So they are naturally and historically have been very closely related. When they form together as a regional organization, they are able to present a common front within the broader organization, CARICOM. CARICOM presents a common front within the Organization of American States. And then you cascade up. So what you're able to do is by forming together and working out common positions, you can use your sovereign, independent votes to gain concessions in ever larger bodies. That's a general enough answer. I don't know if I've answered the question.
Edwini?
Thank you very much. I think I would tend to agree with what the speaker said. But I think you also made the point yourself that the countries also have to do their part. They need to have efficient administrations, because certainly, whereas regional integration can help, but it's not a panacea. So countries, in my view, not even if they are small, They need to have good governance. There has to be transparency in government. They need to embrace or have laws which would encourage foreign direct investment. So all of these are something that can be done internally. As well, I think externally, through regional integration, that could, countries like Luxembourg, we have seen, or for example, Mauritius has benefited a great deal from arrangements with the European Union. So I would say that both in terms of internal and external through regional trade agreements and as well at the multilateral level as well. So it has to be, a three-pronged, I would say, national, regional, and multilateral. I think all of these would help these countries to reverse some of the inherent disadvantages that they have.
Other comments on the broad topic, or do we want to dive a little bit into some of the other questions that have been asked? One of the things that Edwini has said several times is raised the issue of investment and the importance of investment, and that obviously ties very closely into dispute resolution, which is one of the themes of the conference. The premise, I think, is that reliable, enforceable dispute resolution mechanisms encourage foreign investment. There are empirical studies that suggest different things about the reality of that. But if we assume that premise, how do we deal with an issue that's not a regional issue, but ultimately becomes a sovereign issue of how we are getting to I think in Francesco's word, a choice. But a choice, is it a real choice? Do we have a choice if we don't have a developed judiciary, or if we don't have confidence in foreign investors in the judiciary, and yet we don't have a capacity to offer an alternative? How do we move in the right direction? I mean, well, and partly I'm curious about, you've told us the Pacer Plus story to be continued, but where does it go? Where do we go from this idea of developing eventually the capacity to do arbitration? But what do we do in the meantime, and what are the ideas on the table?
Thanks very much. I think you made a point that regard has to be, countries' sovereignty has to be acknowledged. In the context of Pacer Plus, it's actually the other way. Countries are not being given a choice now. And surprisingly, Australia and New Zealand have bought into it, that, you would have expected that Australia and New Zealand would oppose that all investment disputes involving foreign investors and host states should be settled in domestic courts. But to date, Australia and New Zealand have agreed to that proposition. It is rather the Forum Island countries who believe that if they are to attract investment, then they need to assure investors. So they are quite on the offensive that we need to have something more. We do not think resolving disputes in domestic courts would be enough to give investors the confidence. So in our case, we don't have the problem. The sovereignty, I think, for most of the countries, it would appear they think it has gone too far. So it is the Forum Island countries which are pushing for maybe, the view is that I think most of them don't have any experience with arbitration, apart from Papua New Guinea, and Australia and New Zealand accept that. And that's why I think Australia and New Zealand have adopted that position. But their idea is to support the countries, and I think UNCITRAL is doing a great job. They did a seminar for the Pacific Island countries. They are not as advanced as the Caribbean, but I think it was a good step, because my understanding from UNCITRAL, your office in Korea, they are the ones who, they did a seminar for the Pacific Island countries last year in Papua New Guinea, and my understanding is that there will be a follow-up, and Australia and New Zealand have pledged to support as many Pacific Island countries to become signatories to the New York Convention as well. So for now, I think all the countries accept, and I think what is quite surprising is that in Pacer Plus, we don't have a conventional investor-state dispute settlement mechanism, but in agreements which Papua New Guinea, being, well, it's not a small state, it has a population of 7.5, but then again, it is a small state. Their investment agreements that they have proposed, they contain international arbitration. Papua New Guinea proposed a BIT with Solomon Islands, and the provisions in that go further than what we have in Pacer Plus, where the parties would like to resolve any disputes at the domestic level. But Papua New Guinea, because it invests in some of the small island states, it wants them to accept international arbitration. So for now, in the context of Pacer Plus, I think there is the need for capacity building, but I think that is where almost all the countries want to go, that eventually they will need to have international arbitration, because for some of these countries like Nauru, I mean, they don't have any court system. So even if there were to be a dispute, where do you go? There are no courts. Even Vanuatu, they sometimes get judges from Australia and New Zealand. And Vanuatu, relatively speaking, is big in the Pacific. With a population of 210,000, it is big. You know, so it is huge in Pacific. So, but they even don't have the resource, you know. It's routine. They get judges from the Commonwealth. You know, if there are cases, they fly in judges from New Zealand, from Australia. So this is the reality.
Well, it's also a commitment. It's a commitment to accepting awards and enforcing awards, which may have, as you said, I think in your speech, huge impacts. And that's a difficult choice as a government to say we're going to enter into a system that may have consequences that are going to be very, very difficult for us to bear.
I'd just like to follow up on Dr. Kessie. I think that the dichotomy isn't so strong. You have to have a competent judiciary, and in the Commonwealth Caribbean, we have in the Eastern Caribbean Supreme Court a judge who is a very strong commercial judge, and so deals with those things. And we also have the broader Caribbean Court of Justice, which has commercial expertise. But I think that if we're talking about local investment, then those can be resolved in local courts. But I don't think that's what we're talking about here. We're talking about international investment. If we're talking about international investment, most international investors will not feel comfortable, no matter how good the national court is, because there is potential for bias and other compromising things that can arise in public litigation. Copyright, trade practices, et cetera. So they want arbitration. So this is something where I think the South Pacific has a tremendous advantage, because you can just jump right into arbitration. If you have a good set of if you adopt the UNCITRAL model laws and then get states to join the New York Convention, then you can be attractive, because the investors need not be concerned about Vanuatu's lack of a commercial court and can accept that. And so I don't really see it as being the commercial court. Now, as far as that's for international commercial arbitration. International state arbitration, of course, then you have to involve other bodies like ICSID, et cetera. And that's where countries need to find some mechanism which would make an international investor that is entering into an arrangement with a state comfortable that huge multi-billion-dollar project can be resolved outside of local courts.
Does the fact that we're seeing so much criticism of treaty arbitration in the TTIP context make it that much more difficult for countries who are not there yet to even begin to consider this?
Well, some countries are bailing out, but that's a choice that you make, and you have an open shop. You're trying to attract investors. What wares do you wish to sell? And you have to make those choices. And until there's a solid alternative, tried and true ICSID arbitration can work.
I agree with what you're saying, but the question is, do people in the government making decisions accept the points you just made, and starting with the premise that this is good for foreign direct investment, but also that this is the best alternative. And that's I think one of the difficulties here is the academic view, the practitioner view, the arbitrator view, and then the government view.
I've seen a little of all of those views, and governments are very wary of ICSID arbitrations because of the tremendous cost. Just the fees, the court fees alone are huge. We were talking, I think, of bankrupting a state to pay the legal bills, let alone the award. But I think that is a kind of trade-off. Do you want to attract international investors and quality international investors? And these are some of the things you have to think about.
Tim, you've got your hand on the microphone.
Yeah, just my hand on the button. Thanks, because the points raised by Dr. Kessie and Dr. Barry are very interesting. Just first of all, to take a step back, I think one of the problems that states have when they arrive at an investor-state dispute is taking a close look at the agreement they've entered into, they find that they ought to have entered into an agreement that's more favorable to themselves. And a lot of these problems, as contract lawyers know, you don't get big contract disputes when the contracts are drafted in a way that recognizes the interests of the parties. So one thing that's needed is much more assistance to small states in drafting agreements that are not going to be one-sided and are not going to lead to these kind of conflicts. I agree that in a very small state, it's very hard to build the kind of capacity for trust in a judiciary that's going to be very small. And the key to any dispute resolution process is confidence, not only in the parties, but when you're dealing with investor-state dispute, it's the confidence of the public, because these are dealing with public monies and public issues. You're dealing with things like labor laws, environmental law, spending of public money. And part of the concern, rightly or wrongly, you mentioned TTIP and others, is that these are things cooked up by lawyers behind closed doors. And this is where something like transparency in investment arbitration can really be an important confidence builder. We've seen in some cases where, in fact, the tribunal will take into account very seriously the representations of groups from civil society, even going so far as to recognize that something like clean water or proper sanitation is a human right that ought not to be set aside for purely commercial considerations. And if these kinds of things start entering into investment disputes, then I think that can help build a confidence in a system which is otherwise suspect. I mean, everybody suspects lawyers anyway, but we all know that. But maybe something can be done. Something can be done about that. So that's, I think, an important factor. And the UNCITRAL, you mentioned the New York Convention and the model law, and also the UNCITRAL rules. These are, I think, very significant. Well over, or nearly, I would say, a third of the investor-state disputes that are conducted worldwide every year are done using the UNCITRAL rules as the basic rules for disputes. And those rules are now linked to the rules on transparency. So there's a real avenue for having these two things go together. Thanks.
Francesco, you had kicked off this topic. Do you have further comments on your choice question?
Well, the issue is that, to me, the law needs to be seen not only as a tool, basically, to allow investment, but should be seen as well as something like cultural heritage that might be developing, even on a very small scale, in a different way than the one of the, let's say, mother jurisdiction. So the one that actually has influence might be the common law, or might be other mother jurisdictions. And how can the law that basically is a key factor in the sovereignty, develop without any, local court system? And what I'm saying, you might consider my statement as a statement of somebody who is a dreamer, who dreams of a different world and who is not, has not been faced with the reality in small states. But don't misunderstand me. I'm not saying we need a sophisticated court system with, whatever types of. Probably what is needed is a good mixture between, of course, some judges that are appointed case by case. And, even if, I just argued with the Principality of Liechtenstein, and, it had taken a long, long way to get an autonomous court system. It's still not autonomous because there is a lot of judges that are appointed, from neighboring states. So it's not. But still, a genuine case law can only develop also for trade and commercial issues once basically you build up the institutions. And on the other hand, regional cooperation is something that seems to work quite well in many of the represented regions of the world. So we would not necessarily need court systems for each individual state, So anyway, probably reality is different, and probably investors insist, like I guess this was your statement, insist on having basically an international arbitration, figuring out, the cases and dealing with all the sensitive issues.
I mean, there are two different ways this comes up, and we've flagged it on the different speakers. There are private dispute resolution mechanisms that can be done through international arbitration, and then there are investor treaty rights, and they can be different systems, and the law that's going to apply will be different. Do we see particular burdens or difficulties when we have a regional group that doesn't share the same legal history or legal background? I mean, some of the regions we're talking about come from, for better or worse, one legal system in terms of their historical, the roots of the legal systems, and others, and actually Europe, we're looking at a system with many different starting points. And how much of a burden is that in places where we don't have that developed of a judiciary or case law?
Well, I have to correct you. In the Commonwealth Caribbean, we have several legal systems, not just the Commonwealth common law system. We have in Suriname, we have Dutch law. Haiti, we have civil law, French civil law. And so we have several different legal systems. And I also think that that the practicalities, even if you share common law legal systems, the practicalities get in the way. So I did a study of the statutory framework for the Commonwealth Caribbean in arbitration. And it was astonishing, the variance. Some states were parties to the New York Convention. Some states, very few, had adopted an UNCITRAL model law. And some of them had followed more a kind of UK approach, and some of them the pure model law. And then some were parties to the old League of Nations conventions. And that was as far as they got for enforcement. So even within a system where Commonwealth Caribbean states share tremendous similarities and tremendous similar common history, just in legislating, just in bringing into effect the various laws, all sorts of divergences have arisen. And that has real implications. If you are a major multinational player and you are going to do business in the Commonwealth Caribbean, you're probably not going to stick to Barbados alone with a population of roughly 300,000 consumers. So you'll probably want to have some office in Barbados, and you'll want to do trade relations with other states, and you want your products to be in, say, the whole Eastern Caribbean. But if the 7 jurisdictions of the Eastern Caribbean and Barbados all have completely different legal frameworks for arbitration, then you have to hire a team of lawyers. This law firm could be very busy advising their client on all the different jurisdictional issues in all those states. So it has far-reaching implications as a practical matter, even for common legal systems.
We promised time for the audience to ask questions, and I think it's good news we've been racing along, because that means we've been hearing lots of interesting things, but it also means we're running out of time. And so maybe we can pause for a second. I'm sure all the panelists have more things to say, but if we've got questions from the audience, let's take some time now to let people ask questions. And we've got a hand up in the front here, and I think we're going to get you a microphone in a second.
Do I need the microphone? Okay, I need the microphone. Thank you. I'm so used to hollering. First of all, thank you to the panel for 3 fascinating presentations and to an absolutely brilliant discussion afterwards. And as always happens, these things make you rethink what you thought you already knew. And so I have a couple of things I would like the panel maybe to consider and give an answer to. The first is, Francesco, you mentioned about cultural heritage, and it occurred to me that you can't separate international trade from international law. But international law really came out of the European colonization, the conquest of other territories. What do we do now to redress that imbalance? Because when we talk about the weakness of states, quite a lot of that weakness is historic. It comes from the exploitation that went with colonialism. The second issue that you also made me think about was, Secretary Tupou, you mentioned climate change, and I think Timothy LeMay mentioned sustainable development. Great. But that's really not what modern trade is about, is it? It's about private profit, mostly. And one of the difficulties that we have is that for people in country, that's not their goal. Their goal is actually a better life. And when you deal with the governments, yes, they want the investment because it's going to bring money, but it brings money to the government that then is able to spend it. How do we deal with that? And one thing that concerned me was we talked about sustainable, or I heard someone mention sustainable trade, but that's actually not the issue. Sustainable development is about meeting the needs of the present generation without compromising the needs of the future. So if we think of Iceland as an oceanic superpower, could we also think of the Pacific as big ocean states who might be a marine superpower in the future? Thank you.
Thanks. Lots of good questions there. Francesco, you...
Thank you very much. This is a brilliant question because my point of view on the issue is that if we don't allow local decision making, so if decision making happens somewhere else and not in the microstate, colonialism still goes on from the legal from the legal point of view. So if you mentioned that basically the colonialism kind of changed basically the law the law that had been there. Every society has had a law from beginning, and there will always be a law. So colonialism has changed the law, even though the law that has been imported through colonialism probably will continue to exist, probably in most scenarios. I'm quite sure about that. But still, give it at least a local flavor. Give it at least something, some decision making that is bound to the heritage of the culture or in the language, the native language, is something that to me is something that should happen and can happen only if at least a portion of the decision making in the private and public and commercial and non-commercial litigation arbitration is done locally by local judges. So I fully agree with with your point of view.
Mele, do you have thoughts on this?
Just in addition to what has been mentioned, just like to add that one of the things with small island states is we don't have the luxury to sit back and reflect, and see whether we have arrived in where we want to be. Ultimately, what you mentioned about, we need to give a framework for individuals in our little small island states, some space to grow and thrive to achieve their aspirations, individual aspirations. So I guess from a government perspective, we need to look at ourselves again, look at the processes, look at our operations, and see where we need to to improve, so that we can, when we have these kind of discussions on collaborations, we add value on those issues. Those are some of the things that I need to.
And Baldur, to pick on you because I can't see you. I thought I saw you taking notes in response to the question, so I don't know whether you have comments.
Not really, but though I would like to say that I strongly agree with what Dr. Kessie said about the importance for small states to start at the domestic level, to make some kind of domestic arrangements in order to compensate for the weaknesses, and then to transport them to a regional level and then to a global or international level. And I think this path from domestic to international is very important. And first and foremost, you have to start at home, then you can move abroad, if I can say so.
Other comments? Yes, Tim?
Yeah, just quickly, I thought the question mentioned an interesting point, and that is that the what we call the law very much comes from and originates with the colonial powers. Now, when we have international law being made, it's being made, for example, through bodies such as ours at the UN, in which all nation states are taking part. But in fact, if you look at where the nation state comes from, that's a creation of the colonial powers as well. All you have to do is look at a map of the Middle East in 1913 and compare it to the map in 1920, and the Sykes-Picot Agreement drew all these nice lines, and now you have states where you never had states before, and these are the bodies that are making the law at the international level. But that is something that is perhaps unavoidable. At least international bodies now have a forum where at the national level they can have a voice to make laws which have a transnational effect, such as the New York Convention or the model law on arbitration.
I think we've got time for more questions. Oh, sorry.
Just a quick comment on sustainable development. I just want to make a general point that I think the idea that increased trade and investment, I do not think they are mutually exclusive. You can have increased trade and investment and at the same time have sustainable development. So the suggestion that maybe increased trade and investment flows would not promote sustainable development, I think there is a lot of contradiction there. And certainly I think the view of most WTO members is that you can achieve both. If you look, for example, in many trade agreements, because of the WTO preamble refers to sustainable development, countries can also restrict trade on the basis of the environment and other related factors. So I believe that you could, through increased trade and investment, there could be sustainable development in the medium to long term.
Oh, Elizabeth.
Yeah, I just have one comment to make concerning development of marine resources. The Commonwealth Secretariat is supporting blue economy activities in Papua New Guinea and in the Seychelles through our Oceans and Natural Resources Division. Thank you.
We've got another question from the audience. In the front. Thanks.
Thank you. As I understand it, the Caribbean Court of Justice was in part born out of a desire to have a locally owned Supreme Court in place of the Privy Council in London. I think a number of Pacific countries still have the Privy Council as their ultimate court of appeal, and I wanted to know if there was any prospect or appetite for a Pacific Court of Justice along the lines of the Caribbean Court of Justice, embracing both the smaller states and perhaps Australia and New Zealand as well.
I don't think that I'm not aware of any such discussion. It looks like, the countries are content with the current framework, but I'm not aware of having a court of justice along the lines of the Caribbean.
I would encourage it.
Just to add on Kessie was saying in his presentation that there are 14 countries in the Pacific. In each individual country have a court of appeal. Like, for example, in Tonga, it's the only independent country that was never colonized by England. So we have our own court of appeal where we bring in judges from Australia and New Zealand to sit as a panel. And we also have, with certain legal issues, we can only refer it to the Privy Council, where Tonga also has a Privy Council with the King presiding as the head. So I'm not quite sure how we can actually progress with the move to have a consolidated body to hear appeals from all Pacific Islands. I think we are struggling as we are in trying to find Court of Appeal judges who we engage on a part-time basis. Thank you.
I think maybe we'll squeeze one more question in. Unfortunately, this is going to be our last one.
My name's Jeff Sharp from New Zealand. I just want to pick up that question about a Pacific court. When New Zealand quite wrongly moved away from the Privy Council and created our own Supreme Court, there was discussion around a Pacific Rim court. And I think there were discussions, whether openly or covertly, with Australia and whether we could borrow some of their High Court brain surgeons, but nothing ever came from it. It got very political, and I think I agree it was an opportunity missed.
Thank you. As I said, unfortunately, I think our time is up. Fortunately, we have a lot more time over the next day and a half to keep talking about all these topics. If we could stop and thank both our keynote panelists for getting us started so well, and our commentators, I'd like to show you our appreciation. Thank you.